Artificial Intelligence, Law and Justice, Session 29, AI and Competition Law. As usual, we will do a recap of the previous session. In the previous session, we discussed about AI and health law, particularly in the context of developments in AI that are enabling a lot of developments in health, particularly primary health, diagnostics and other things. So there is a need that health law should also get updated with these developments and also should be able to meet the needs of the society. On the other hand, we also discussed in detail about some of the issues that are emerging, particularly on account of the digitization of health records and then electronic health records in various contexts, particularly privacy, data governance, lack of uniformity in data governance. We also highlighted that why data in health law is also equally important to many stakeholders because they have different perspectives on it. So we also mentioned that AI and health law is an emerging challenging area where a lot of things as of now are fully not resolved. Having said that, let us look into an equally interesting emerging area where a lot of developments are happening. We discussed in detail about AI and patents and AI and copyrights. But competition law is something that is equally important in a society where government wants market forces to operate freely without any monopoly or oligopoly emerging, and then free market forces should also be the ones that should empower consumers instead of they becoming caught up in various commercial webs or commercial transactions uninformed or they let into traps by the various companies. So what exactly we are talking of here? First of all, AI in law and regulation, we should know that there's a technological neutrality in lawmaking. The central principle is that any emerging technology will be regulated with a technology neutral in the sense that it will be applicable for all technologies. So the focus here is then on the activities than on specific technologies. Or to put it more specifically, whether it is nanotechnology or biotechnology or cyber technology, focus is on activities, what is feasible, what is getting done, than the technology per se. And then idea here is to regulate people's behavior and market behavior affecting people rather than government through regulation trying to fix certain things or trying to direct the innovation to go in such a way. Then the focus is broadly on the societal impact, which means that idea is to increase consumer welfare so that the innovations are for the larger societal benefit. Then intellectual property rights, their protection is equally important. So that is one of the core objectives of competition law. And then copyright incentives, we know that. Patents we have seen in detail. And then trademarks are also social value and legal protection. So competition law is also equally concerned about intellectual property rights being protected and also safeguarded. Then what we call as antitrust laws and competition is something very important here. Antitrust is a typical US name, whereas competition law is the name that is used in other countries. So basically antitrust is anti-monopoly laws, we can say, or the government or the society doesn't want few corporations or a cartel of companies to decide everything, sharing everything among themselves and then including price fixing and other things. So the challenges in regulation on account of these, when AI is a major player or when AI makes certain things happen which were not earlier possible, results in lots of tensions as well as the need to look at very creative solutions. To begin with, competition and democracy is equally important because competition promotes material progress, quality and innovation. It supports democracy by enhancing the choices available to people, and then it also enhances the opportunities there. More importantly, competition is something that where governments allows the market forces to play freely on their own without government trying to be the hidden hand behind. So idea is here that while legitimacy of the market forces should be there, that should not end up in illegitimate monopoly or oligopolistic power or few cartels deciding on everything. So in the digital economy, what has happened? The digital economy is very different from brick and mortar economy or the regular economy where physical markets play a major role. Whereas in digital economy, lots of transactions happen at the flick of the moment by people sitting somewhere in the world, ordering something, transacting in enormous volumes, both in terms of quantity as well as in terms of currencies. So the problem is that digital markets, although they are markets, they are global in nature, and digital economy is equally global in nature. So the governments have to really tailor make some policies and regulations to govern the digital economy. And then digital economy competitive advantage is also equally globally. Since that a digital economy which comprises of, among other things, e-commerce is expanding day by day, but then there are no specific broad trade rules under WTO to govern digital economy. So this is again linked up totally with digital technology, because digital technology is the backbone of digital economy. And then customer protection here is also linked up with data protection, obviously. And the major role where AI comes in is on account of the algorithms and then automation of the digital economy. So we are talking about many things here. We will go into detail one by one. AI as an intangible capital asset. Obviously, AI is not a very tangible asset, although AI may be operating through large data servers, large centers, undersea cables and all. AI itself is an intangible capital asset like knowledge. And more importantly, investments in AI can enhance productivity, this is obvious. And then when we talk of AI, the applications are so broad that ranges from voice recognition systems like Alexa to autonomous driving vehicles to so many applications that are integrated into AI systems which can span across continents. And then what exactly is the impact of these things on legal technologies? AI, as we have seen, affects the legal services in more than one way and also access to justice. And more importantly, we have already seen that AI raises a lot of questions for regulation and equality. Now, when the global digital economy is getting transformed on account of the digitization, parallelly, a lot of things are also happening on account of developments in AI. And problem here is that AI developments also influence various sectors on account of the novel applications, innovations, and the way AI marches ahead. And more importantly, AI can be a good tool for gaining competitive advantage. At the same time, AI can also be used to obstruct competitive advantage or to promote monopoly or to block the market forces operating freely. So the competition and market dynamics that could get impacted on account of AI and vice versa is at the cornerstone of AI and competition law. Market and competitiveness. Markets and technological innovations are too obvious to know. So technological innovations make many things possible. They bring in a lot of developments in the market. They facilitate enormous volumes of trade in terms of both quantity and otherwise. And then they facilitate faster settlement. They facilitate faster transmission of information and all. More importantly, this also facilitates to a great extent decentralization, in the sense that the buyers and sellers can be anywhere in the world, but they can be operating through various e-commerce sites or on their own. So there is a lot of disintermediation that is happening. At the same time, there are a lot of new intermediaries that are also emerging in different sectors. And profit is the key driver for a technology innovation, that is obvious. So we are seeing when digital economy spreads or when digital economy grows, many things happen, including new intermediaries arising, disintermediation also happening. And then competition law is also something that is linked up with economic coordination. Competition law has to deal with problems of imbalances in power structure on account of the developments in e-commerce and how AI, particularly algorithmic trading, affects that. And then there is no overarching legal framework for this. Whereas digital trade itself is very new. But the regular trade or the brick and mortar trade is governed by different rules and then by different logic. And more importantly, we have evolved over centuries well said legal principles, legal institutions, and then binding contracts, and then so many other mechanisms. So translating them to digital commerce is a big challenge. Two, how do we fit in the competition law principles to this is another challenge. We have seen about competition and IPRs. The central role of IPR is to create wealth through novel innovations, and then they facilitate new economic development. At the same time, these innovations also spare a lot of productivity, the society overall benefits. So IPR is closely linked to competition policies as well as to foreign direct investment flows. Why? Because foreign direct investors or foreign direct investments often are decided by the level of protection, IP protection offered in a country. And more importantly, in a global market, all the foreign direct investors or the multinational companies are the ones who are the major investors through foreign direct investment look for countries where rates are strongly protected, piracy is not promoted, and then government has got a mechanism to ensure that IP rights are not fully protected, enabled, and then there is a dispute settlement mechanism that is reasonable and justifiable. And equally important is that IP rights may rise to monopolistic behavior. So government should bring in competition law to ensure that anti-competitive practices are curbed, if not fully constrained. And then what sort of mechanisms governments will do is a different story which we will not get into. But when it comes to AI, picture gets little complicated for the simple reason AI, big data, cloud computing are transforming the global economy, and they are also transforming the global data flows, data economy, the digital economy and everything. So digital platforms are offering new products and new services, and in fact digital platforms today are not mere platforms. They offer or they act as platforms with multifaceted platforms. They may be the one where marketing happens, they may be the same ones where content creation also happens, and some of the big data digital platforms are also offering so many other things ranging from cloud computing services to acting as intermediaries. So there are a lot of monopolistic or antitrust concern over here. And then how do you ensure that IP rights are being protected in the digital economy is equally important. And particularly in developing countries, how to ensure that IP protection happens in the digital economy, where digital economy is now getting to flourish. So in all these, we know that multinationals prefer safe locations where their investments are safe, IP rates are protected, and then they expect that there will be some specific set of rules to guarantee that their business is not unduly hindered. So they look at areas where advantageous technological assets can be deployed, and then their investment pattern, investment behavior also depends upon so many other criteria, and then they are like free flow of capital, investments, technology across the world. So IP protection is equally important. Digitization is also equally important. But what has happened on account of these digitization and then the global digital economy is that many multinational companies have found within quotes tax havens to benefit from digital economy. So in these tax havens, what they find is that some countries offer in the name of promoting digital economy and other incentives, tax-free or some sort of incentives where you get some reimbursement or whole lot of other tax incentives to locate your investment in a company or to locate e-commerce in a specific country. So this what happens that the companies through e-commerce digital platforms, they shift the profits to countries where the profit is taxed very least or there is no zero tax. So there is a demand that the global corporate tax of 15% should be levied across the global all the countries so that countries do not take the advantage of some countries promoting digital platforms, e-commerce, digital commerce, digital economy, and then also offering incentives for on account of lower tax rates. So this is something where competition law has got a lot of things to play. And then next comes the issue of competition law democracy, which you have seen. First, the competition law principles that outright certain things can be prohibited if they do not promote competition or they are constraining the market forces or they result in sort of monopoly or duopoly or oligopoly. And then the goals of the competition law is to safeguard competitive process, balance consumer welfare with market-driven pricing, and ensure that monopoly or oligopoly is restrained. But algorithms, as we have seen, are there in the part of the AI. And then there are a lot of dynamic pricing algorithms. These dynamic pricing algorithms, we may not be able to see them physically, but then they operate. For example, when you book a cab or when you do a cab aggregator or any such service, there's a dynamic pricing algorithms which fix the price depending upon the demand and supply and other parameters. But in e-commerce and other travel sectors, it happens in a different way. In the sense that if you book a flight ticket, you are not the one who is doing a flight ticket on the web. At the same time, directly or indirectly, thousands of people may be doing it. For example, if I am booking a flight from Hyderabad to New York, I am not the only one in Hyderabad to New York to booking for that thing. Somebody sitting in Muscat may be doing the same thing. Somebody sitting in Mangalore may be trying for the same thing. So these algorithms, they look at all these transactions, and then the dynamic pricing happens when all the travel agents or the travel companies are able to know the supply and demand and then fix the price accordingly. So what they do is that they use the algorithms for it. The digital companies on algorithms for settling prices. And what the algorithms do, algorithms can facilitate tacit collusion. No, the tacit collusion, what is collusion? Collusion is two or three companies or two or three persons coming together, working together either to subvert a rule or to maximize the benefit on account of the sum of the transactions that are bound to happen or in the process of happening. So the technology's advancements enable personalized pricing strategies, which means that the companies can make personalized pricing strategies depending upon the consumer, depending upon the past behavior. That is one aspect. And algorithmic pricing can affect market competition in more than one way. For example, if the 6 or 7 travel aggregators decide that given the huge demand versus the availability of cars, they will fix such pricing for this hour or in this direction or to this destination. And then the algorithms will tell the cab aggregators on the demand and supply where the direction is there more or where the demand is more or where the cabs are also located. So it is possible using algorithmic pricing in a dynamic way to avoid market competition or to fix a minimum price, which again will be against the consumer, because if I say I choose option A with one cab aggregator, if I find it too high, I want to go to option B, which is another cab aggregator. But if all the cab aggregators come together and then have a tacit understanding or have an informal understanding that all of them will apply surge pricing at this time for this route, then I will be not just I, whoever's looking for cabs at that time for that location will be the ones who will be paying the price for it. So this sort of algorithmic pricing actually affects the market competition. It is not allowing the market to decide the fare. Rather, the fare is pre-fixed or it is getting adjusted depending upon what the cab aggregators decide on demand and supply. In one sense, they are also manipulating demand and supply so that those who want to still prefer such pricing, they can go. But then not all markets are possible in the way that often people's choices are limited. So even if it's more expensive, more consumers will prefer that because there are no cheaper options available. So the benefit of the algorithmic pricing is that it helps them to maximize the profit by adjusting prices based on supply and demand, or rather giving them the option to fix the prices in advance by looking at the supply and demand. At the same time, in some circumstances, it could also increase consumer supplies by reducing the prices. But what is important is that this prima facie results in market distortion by ensuring that the aggregators on one hand and the consumers are on hand. Aggregators try to tend the balance in their favor by behaving in an anti-competitive manner. So this needs to be regulated, and then some sort of compliance has to be brought in. What I am talking of is only cab aggregator, but then the whole lot of thing happens in travel, in any demand and supply on account of traditional e-commerce. For example, if there's a demand and supply gap when it comes to certain medicines, the same logic will also be applicable. And then the consumers, if they're scrambling for something, depending upon the availability and other things, which the distributors and producers would know, because everyone has displayed their warehouse and everything, as to how to fix the price so that nobody sells be less than a minimum price, and at the same time nobody offers any discount for that particular product. So the dynamic pricing of algorithm results in lots of collusive behavior which is done at the cost of consumer. So why this happens is that e-platforms hold power. Now the extreme concentration of wealth and power happens because e-commerce in most countries including India is at the hands of a few or a maximum half a dozen corporations. Amazon, Flipkart and then few companies are the ones who dominate in India. Throughout globally also you would find that about half a dozen companies in different countries are in a dominant position. So the power with e-platforms which are able to play a very dominant role. And then what they do, they also look at who is trying to buy what, who is demanding what is the demand and supply they monitor through data surveillance, and then they do a lot of data harvesting. Data harvesting is nothing but simultaneously harvesting from different websites, from different screens as to what is the demand, what is happening. And then this is something like monitoring the consumer behavior, where the consumer's attention is going, what the consumer's prices are looking for, like that. And this is resulting in an oligopolistic platforms where social networks and then search engines use the free content which we provide, because we are the ones who are in the web. We will search for certain things using a search engine, or we directly go to a website and search. And then data harvesting happens because they monitor our behavior, they monitor our IP address, and then they know that this person is looking for two or three things simultaneously. He is booking a ticket, he is also trying to book a travel ticket, he is also trying to buy some groceries. So they use our advertising personal data for advertising, and then for targeted consumer advertising, and then also to specify specific products and goods that could be offered to us. So these platforms, half a dozen of them, hold enormous power, not just on account of their e-commerce power alone. They have the power to monitor our behavior, the data we provide to them, and then they also shape our perceptions. They also try to shape our behavior by offering us some discounts, or they are trying to alter our behavior so that we move towards what they want us to buy. So this indirect control over consumers' options, spending and political positions is something that is not a good behavior. And then this is precisely the problem with social platforms, e-commerce platforms, which are very powerful. And then the fair use doctrine and then dominant platforms is a very important issue. The dominant platforms do not tell as to what exactly are they harvesting data, and then how are they using, and they do not even tell you that they are using it only for specific purposes, because they collect enormous amount of data. They have the previous purchase data, and they are able to correlate, build patterns, even guess as to what you would be buying within the next 24 hours or the next week. And then they use the AI technology not only to survival our behavior, but also to disseminate information to us. And more importantly, these are also in many instances tied up with commercial media organizations. So the platforms becoming huge, unwieldy for the government to regulate, at the same time too powerful, becomes an issue when we talk of AI and competition law. Precisely because as platforms become too powerful, competition law has to step in to ensure that they do not abuse their power. So the digitization is equally important. Digitization should result in a broader decentralized digitization where anybody can flourish: small, medium enterprises, small dealers, handicraft producers and sellers, someone who is operating from the home, self-employed women, like that. But what happens when the market power gets concentrated in few platforms, or in set of companies or the platforms where everything is decided by them? Many players get either lost out or they get co-opted on these terms. So the digitalization and digital entrepreneurship could get skewed totally in favor of platforms and then other larger entities if competition law does not step in there to protect their interest. And then digitalization, as we know, is a game changer now. So even to promote digitalization and digital entrepreneurship, or to come up with a level playing field for all, competition law is necessary to prevent abuse of the algorithmic power, abuse of the oligopolistic power. That is why AI and competition law is getting more and more equally important now. So the algorithms can mimic human intelligence, which we have seen, and then the neural networks can rather manage complex problems. So the algorithms can mimic our behavior, they can try to manipulate our behavior. So one way is that if I am misled by AI based algorithms, if my behavior was distorted or targeted towards something which I did not want really, or the options which were given to me were wrong, or I was forced to choose something which I did not want, but I was laid a trap, or I was asked to choose only the available options, although there were many more options were there, but then they were not given to me. Then the tort law principles can set in, where I can say to remedy the injuries done to me, I will use tort law. So the negligence on the part of the e-commerce platform or the e-commerce dealer could be negligence to perform the duty, breach of confidence, unauthorized use of my data, and then damages would be done. Of course, it could be that they could say that we did nothing wrong, we have only tried to help you out, and then there is also a clause that the choices were ultimately yours, we didn't force you, and then you also gave consent. So automation, AI driven algorithms, particularly the autonomous vehicles that run on AI, based on AI, and then the robots, these are some of the potential areas where AI torts can play an important role. But in case of competition law, the larger and severe damage could happen on account of AI based algorithmic decision making by the companies, not by us. And then the way they will collude between themselves, do some price fixing, acting as a cartels that either block some options are available to us or throw up some options which we really know that are not the best options available to us. So how to challenge these things, and then how to ensure that the AI is used in the digital space in such a way that real competition is fostered and then oligopolies and monopolies do not arise. Often you know that many of these things come up with terms of use and liability. For example, E is a robot assumes no liability for errors and inaccuracies, including documentation, files, and software provided. Same thing you would have seen across many e-commerce sites, digital e-commerce sites, and then digital platforms. So ultimately, they try to escape the liability by putting these clauses. But the collusion which we talked of need not always be very explicit, in the sense that there is no need that there should be written agreement among the e-commerce players that they will collude among themselves in some price fixing and then force certain options to us. No, it never happens. It could be very tacit, in the sense that it could be the one that controls their behavior. Tacit means it is given understanding, informal understanding, not something that is written in law or not something as a legally bound contract. So express collusion comes express agreements, but then this is not the norm. The normal is tacit, informal agreements which happens on a day-to-day basis depending upon the demand and supply. And then by intelligent market adaptation, in the sense that you look at the demand supply, you look at the number of consumers, you look at the movement of the flow of the information, you look at the movement of the traffic, and then intelligently you can adapt the price, you can manipulate demand, you can manipulate supply. One way to look at this is algorithms can be stated as illegal agreements, because by default these agreements facilitate monopolistic power. And when companies use these algorithms in such a way, it can result in consumer loss. So algorithmic based pricing could be in such a way that consumers are left with no choice, or they have to go for the choice that is offered to them in a very unrealistic way. So the regulatory challenge for the regulators is that how to identify these things as the real issues, or even how to prove that there is a collusion that has happened in the first place. So we need to define the importance of algorithms, or we need to look at the importance of algorithms here. 1/3 of the best-selling products on Amazon in 2015 sold were through algorithms. By now it has increased so much. Higher prices and sale volumes absorbed for algorithmic sold products, because they were the ones that were prominently proposed, promoted, and then projected with lot of incentives. When European did a sector study, it found that two-thirds of the e-commerce retailers, online platforms use algorithms. Algorithms you have already seen, sequence of rules performed in order, generating output from a given input, and then it could be solving a mathematical problem, it could be putting together an order from different buyers, and then targeting certain buyers and then sellers, and then it could be something like creating a marketplace where the buyers are locked into some sort of patterns in the sense that by if you want an 8 GB mobile phone with 8 GB memory, two or three retailers can force you to buy a 16 GB thing by offering a false choice or by unnecessarily hiking the price of the 8 GB mobile phone. Or they could come with something like, since we want to promote this model of this capacity, we will increase the price of the 8 GB mobile phone exorbitantly so that consumer will tend to opt for the 16 GB mobile phone. So these are some of the things that are really happening. But how do we define algorithms, particularly in the context of e-commerce? Some algorithms are meant only for monitoring. They monitor market, they monitor competitors' behavior, and then customers through scraping. Scraping is nothing but collating data, and then sorting it from the behavior. The sense that bots do it all the time, 24/7 in the web. And then they help competitors to look at each other's products and prices. In the sense that they know that I am watching you, you are watching me, and we are watching everyone else. But in a cartel of 4 or 5, if one member decides that member will offer a special price so that he will violate the rule of the cartel and then but still will gain a good market share, this will make the cartel other members to instantly retaliate by the cartel member who is not obeying the cartel rules. So what they would do, they would try to indulge in price war, or they will try to indulge in setting a false competition that they will suddenly announce discount, or they will come up with some proposal, or they will manipulate the prices that the cartel member who actually defects or who did not obey the cartel rules will be in a disadvantageous position. Imagine in a cartel of 5 or 6 retailers, if one retailer decides that he will offer about a discount of 20% against the norm set by collectively just to promote his or her market share, the other e-retailers can decide on few things. To punish you, we will make our things available at a lesser price. If you are offering 20%, together we all will decide that we will offer a minimum of 15% so that the margin of 5%, which you had the margin of 10%, now we have a margin of 5% in our favor and all your consumers will come to us. So this collective retaliation, instant retaliation is possible because everyone is watching everyone's behavior in the market. Then the pricing algorithms, they work more like neural networks, the way we look, matching, comparing prices, looking at where the minimum price, maximum price, where the difference is this much, and all they fix the price by reacting to changes. Then the first generation, they simply go the simple pricing mechanism. Okay, if this is the price, offer this. If not, offer that. Very simple pricing mechanism. They are not very dynamic. The second generation is very dynamic, depending upon the demand and supply and market forces and availability. In the sense that how much of that is available in the warehouse, how much of that is being demanded, they can fix the prices. And then the speed of prices update from weeks to seconds, in the sense that the prices will vary from second to second. If you try now, if there is a collision happening and then if all of them decide to suddenly to outsmart someone, offer 10%, it will be available now, but a minute earlier you would not have been able to see that. Then there are signaling algorithms. These signaling algorithms are like sending a signal to the other competitor this is the demand, this is the supply, and this is where we need to fix our price band, and this is where we need to ensure that the prices do not change exorbitantly, or the margin of the prices fluctuating is 5 to 10% or the norms which we have decided. Mind you, all this is happening simultaneously at the wink of a moment and then without any human intervention, because algorithms on their own can rule, algorithms can monitor and then decide. But some of the algorithms are transparent and clear so that it's easy to locate them. Some of them are like black boxes. So the first one are called white box, the second one are called black boxes. Normally what happens is that the black boxes ones are the ones which are mostly used in all the e-commerce sites, because they work like human thought, but then it cannot be inferred or a third party won't be able to recognize how they work. And then the users are powerless, users have to only give inputs, they can't decide on this. And more importantly, since they can be defined and defended as source code or trade secrets, courts won't be able to infer from them or cannot ask them to deconstruct or make the code available to them. And then there are adaptive algorithms which are with fixed capabilities, they cannot improve autonomously. So they go by what the programmer says, they are more like step by step, 1, 2, 3, 4, 5, they don't do much work. But the learning algorithms, which are the dynamic ones, which are very agile and then which can learn from their own behavior, which can pick up cues from the market, are the ones which are mostly used in e-commerce sites. So over the period of, they become more better, more agile and more lateral, and more importantly, they can modify themselves to improve their performance because they learn. They have the capacity to self-learn. So after 500 iteration, or after being in the market or in use for about 2 to 3 months, they would be able to gather more information, fix the price more instantly than they were introduced in the first place. So this is the way the learning method of algorithms can be used to manipulate market. And of course this we have seen, white box, black box and all. And then functional also this we have seen. And then interpretable also we have seen that. And then this also we have seen. So we need to now look into the features of collusion. Collusion is when, as we said, competitors or the players in the market come together with some ulterior motive, either to raise their profit or to hold their share together. So one way is that competitors coordinate actions to raise profits. The action to raise profits could be either offering discount or to fix a basic minimum price below which nobody will sell. So OECD has defined this as joint profit maximization strategy harming consumers. And then there is a coordination among competitors is equally important. We have seen that through algorithmic dynamics it's possible. And given the gaps in demand and supply, a carefully coordinated collusion can result in super profits, particularly if it is in something like food items or medicines or for travel, particularly in seasons, holiday seasons, where consumers do not have much choices or the options available to them are narrowed down on account of the algorithmic behavior. So ultimately consumers pay a huge price because the market is distorted, market forces do not operate with a free hand, and more importantly, collusion ensures that profits are maximized, consumers are duped to the maximum. So in US, if this has to be proved, then conscious wanton agreement, the presence has to be proved. Whereas in EU, even if the communication among rivals is good enough to prove that. But in some senses, tacit competition, collusion is tolerated by competition law in some countries because it is taken as a normal behavior, although it does not often result in good consumer welfare maximization. But again, the competition law is not something that always favors tacit collusion or that thinks that's the best option which should be permitted. So how do we define collusion itself among economists? There are multiple views. Harrington defines emphasis as a reward punishment mechanism where the collaborators or the market forces or the ones who are colluding have a reward collectively behavior, well behavior, punish the one who violates the rule. So with or without collusion, according to him, super competitive prices can occur. But critical to collusion is that it's the current conduct with future conduct. And then you can also infer collusion through casual behavior, although it might be very tacit. But the real problem is that how do we prove there is a direct communication or an indirect agreement or a direct behavior that could be monitored and then mapped with the behavior? Very, very difficult to prove. But then focusing on agreement of mutual understanding, there would not be any written agreement to that effect. So the differences between law and economics is that economists look this from a different economic perspective based upon the microeconomic behavior of the market players, whereas law looks at it more from a behavior that promotes competition or that hinders competition. But collusion happens in some circumstances where there is a structural facilitation is happening. For example, market is getting highly concentrated with few players, then the same players have very small or similar cost structure, and then the products are very homogeneous, and then the other players will find it very difficult to enter into the market because of higher barriers to enter on account of higher cost, or the market is being held by few players who do not offer space for others to enter and then deal with the consumers. And then there is lack of transparency in the market, and more importantly the demand is stable and huge, and then there is a frequent demand by the consumers. So under these circumstances, collusion can happen more frequently with more powerful players. So in concentrated markets, collusion can be a very effective, powerful tool by the colluders against the consumers. Then algorithms, as we have seen, they facilitate collusion in more than one way, because they assume that all the sellers are able to come together, work together without having any specific agreement. Then autonomous algorithmic collusion does not need human intervention. For example, if all the market players, 4 or 5 digital e-commerce giants, tell their algorithms that you look at the behavior of the algorithm, you compare the prices, and on your own you choose this as the base price or the minimum or the maximum price. Similarly, if everyone does the same thing, the collusion happens without any human intervention. Or humans decide to collude and then algorithms facilitate it. But the problem is that the legality of the collusion is unaffected by the use of algorithms. Or you cannot take a stand that it was not me, it was not us, it was algorithms who decided. But it is possible to pursue this under US antitrust law or US EU competition law to prove that there has been a de facto algorithmic collusion, although there is no written agreement. The behavior can be seen, it could be inferred from the behavior that there has been a algorithmic collusion. But is it technically feasible? It's highly doubtful to do so. And then prominent commentators argue that algorithms can achieve tacit, but then that doesn't mean that every time tacit collusion happens, algorithms are the one that should be blamed for. So experimental studies also knew that they can collude in certain settings, but not necessarily always. So what should be the future course by the competition law to prevent that frequent collusion of the algorithmic forces does not result in reduction of consumer welfare or consumers being taken by a ride by these e-commerce giants? This we have seen, and then we will not go into the details here. Hierarchy and such, they classify humans use algorithms to execute collusion, express collusion among human agents. So minimum algorithmic autonomy is there. It is not that algorithms have fuller autonomy. This is one view. The other view is that common algorithms are being used by the competitors, there is a higher degree of algorithmic autonomy because all of them are patterned on the same logic, same structure, and then same decision-making thinking. So, it is to be inferred that there is indirect communication through the hub by these different algorithmic agents. And then this results in a predictable algorithmic scenario where the agents behave in a similar way. Although there could be no tacit or explicit written agreement, the algorithmic behavior of different competitors itself can result in an inference that there has been a collusion facilitated by algorithms. But then there is a whole lot of debate on tacit collusion, whether it's reasonable, whether how do we approve it and all, and then how should we go about it. So its legality has been questioned. There are multiple views. Posner is a famous law and economics legal expert in USA whose thinking has been a very influential one globally. And according to Posner, they support prohibiting tacit collusion because tacit collusion per se results in less of consumer welfare, more of market concentration. They result in consumer harm. But the current approach focuses on lack of direct communications. But then algorithmic tacit collusion happens in varied market structures. So increasing the transparency and then increasing the reaction speed facilitates collusion. So we should increase transparency and also see how much of that is being facilitated by high volume, high reaction speed. Algorithms can in fact signal price to the intentions to different by sellers in the market so that they between themselves get the signal and then accordingly change the rules. So rethinking the terms of coordination among firms has to be deciphered and then they should be rapidly decided, detected and then retaliated. But then the challenge is competition law agencies or the ones who institutions may not have sophisticated power to monitor it and more importantly to prove without any doubt that there has been a consumer harming behavior on account of algorithmic collusion. So to conclude, debate on algorithmic collusion is not fully settled and there's an ongoing controversy, but then proactive by competition law agencies is equally important because algorithmic collusion has become more or less a routine practice by the monopolists in the e-commerce sites and more importantly, they should take a clear-cut stand against algorithmic collusion. How do we minimize algorithmic collusion is one way is to ensure that by design it is prohibited or minimized. And ex-ante regulation. Ex-ante regulation is that the regulators, after looking at the behavior of the players, particularly the dominant ones, and then their impact, if they come up with a conclusion that there has been a algorithmic collusion behavior and then the sellers have come together and they have harmed the consumers, they should be either asked to refund the balance or refund the maximum from the maximum how much they have received, or they should be punitively damaged. For example, 100 million euro fine for colluding in the travel sector during the Christmas season, or by trying to mislead the consumers by manipulating demand and supply, or by trying to mislead the consumers in such a way that the market forces are being distorted and consumers end up paying more when actually they should be paying much less because of the distortion. There should be a competitive fine for the major players who did tacit collusion to maximize their benefits. So ex-ante regulation tools can also be used. And then the literature on competition law and AI is emerging like anything. I've barely scratched the surface. In fact, even talk of algorithmic collusion and AI itself, we would need at least 2 to 3 hours to get into the technical details as well as the both economics and the legal perspective. So the literature given is very selective. Now coming to the Indian context, recently it has been risked that Competition Commission of India is also looking into the risk of algorithmic collusion happening in the Indian market and is trying to look at what are the possible options available to that. In fact, the Commission of India is very much aware of it. That is why it floated a digital competition bills draft quite some time back. The comments have been received, and then very soon India is likely to have a digital competition act which could result in curtailment of this algorithmic collusion behavior. And there is also an increasing literature in India on account of this algorithmic collusion, particularly the way AI is interacting with the market forces, digital platforms, and then what is happening in algorithmic collusion facilitated by AI. So I've given some literature and also shared a news item to that. As explained again, we have just barely scratched the surface. In the next class, we will go into AI and law and justice in select jurisdictions. This will be delivered in 2 sessions, with the first session being the next class. Thank you.